I'm Drew Stevenson, and this is a lecture for my Statutory Interpretation and Regulation class about the case Corning Glassworks versus Brennan. This is a 1974 U.S. Supreme Court decision that we're really studying because of the way that the court refers to and uses legislative history, which is a little different than in some other cases. A couple quick things for my students. First, this is an employment law case. I don't expect you to know everything about employment law at this point in law school. And so I'm just going to give you the basics of the facts in the law that you need to know to understand this case. We're studying the case to really look at how the court uses legislative history here. And if you read the case, that's what you should focus on, is focus on the sections about legislative history and really look at what the court is doing, because this case is a little different than a lot of other cases where they just refer to what the sponsor of the bill said or a subcommittee report or something like that. So let's look at what happens in Corning Glassworks. By the way, the statute also involves some conflict between some sort of outdated and then repealed state statutes and a new federal law of anti-discrimination law. So we start way back in the old days. At one time in the early 20th century, New York and Pennsylvania had state laws that prohibited women from working at night. They couldn't work the night shift. I'm not sure why they had these rules. I can sort of guess that either it was concerns about public safety, and in an era when a lot of people walked to and from work, that women would be walking home alone at night from their night shift, or maybe it was based on sexist reasons that they thought that women should be at home with their families, making dinner or things like that, or it could have been another reason that actually we're going to see in our next point, that at the time, remember, working night shifts was really came about only after we had electricity in factories and had light bulbs. And so night shifts at factories is sort of a 20th century phenomenon with the widespread introduction of lighting. And at the time that they had these laws, people thought that working at night was terrible, right? And in fact, most of the people I've ever known who worked night shift thought it was terrible. It's hard on you physically and you're out of sync with the rest of society. It's hard to go to a doctor's appointment. You have to sleep during the day when everybody else is up, and so forth. And so maybe they thought it was just too grueling for women to do. I don't know why, but at some point they have repealed these, but you should be aware that that's what sets the stage for this. So Corning was a glass and they make dishes for cooking and plates. They kind of pioneered Corel plates and stuff like that. And they had a factory in New York. And what they did, because women weren't allowed to work the night shift, once they had a night shift, they would assign men who were working during the day shift to be inspectors on its night shift. So they had some men who were willing to work at night, and then they needed inspectors. So they would pull inspectors off the day shift and assign them to the night shift. Well, again, working at night is terrible. And so the male employees basically demanded and received higher wages for working the night shift. So far, so good. They weren't demanding higher wages than women, but they were getting higher wages than women who were working the day shift as inspectors. So the result in practice was that the day shift was all female and the night shift was all male employees. And the night shift workers made more originally because you had to pay people more in order to get them to be willing to work the night shift. And so what happened, though, is New York and Pennsylvania eventually repealed these outdated gender-based laws, these no women working at night laws, but it took a while. Corning didn't immediately eliminate these pay differentials. And I want you to understand that, at least purportedly, the pay differential was not just to give them men more money than women. It was that you had to, if you didn't pay people a premium to work the night shift, no one would do it. So they paid people more to work at night, but it happened that only men were working at night. Now, then enter the 1963 Equal Pay Act, which provided that no employer shall discriminate between employees on the basis of sex by paying wages to employees in such establishment at a rate less than the rate at which it pays wages to employees of the opposite sex in such establishment for equal work on jobs performance, the performance of which requires equal skill, effort, and responsibility, and which are performed under similar working conditions. And so the night shift supervisors, and this is really about the inspectors and supervisors at this factory, the ones who work at on the night shift are paid more than the day shift ones, but the ones who work at night are men, and the ones who work during the day are women, and they're doing the same job when they're at that job. Now, the Act then contains an important exception right where I left off on the previous slide, and that's the issue in this case, except where the payment is made pursuant to 1, a seniority system, 2, a merit system, or 3, a system which measures earnings by quantity or quality of production, or 4, a differential based on any other factor other than sex. And so just to make sure you understand the exceptions that we built into the Equal Pay Act, if you basically pay people a premium who have been there longer, right? You have sort of a seniority is reflected in the pay. Then it's okay that somebody who's been there a lot longer is making more money than like a man who's been there a long time is making more than a woman who just started, even though they're doing the same job. If when the woman has been there for a long time, if she will also make more than men who have just started. Or a merit system, things based on productivity or how good of an employee you are, or things like that, and or earnings and so forth, like for sales, for commissions, and then it has this catch-all or any other factor other than sex. So Brennan comes into this case because he was the Secretary of Labor at the time. And I don't think he personally did this, but basically the Department of Labor filed actions against Corning, claiming that it was violating the Equal Pay Act. And at the time, if an agency got involved in litigation, usually the head of the agency's name would end up in the caption of the case. And hence Brennan was initially the plaintiff, and then as you know, the sides get switched when it goes up on appeal. So the Department of Labor said that the pay differentials between the day and night shifts actually didn't comply with the principle of equal pay for equal work, because really they were doing the same job. Now, here's where we get to the legislative history part, which is really the only reason we're reading this case in my class. As originally proposed, the bill required equal pay for, quote, equal work on jobs, the performance of which requires equal skills. But then they had witnesses come into the committee hearings when they were working on this bill who said that the definition didn't really coincide with what was going on in the manufacturing sector, and that companies had these things called systemic job evaluation plans that American industry was using to provide equitable wage structures. So they would sort of evaluate the different jobs at these huge facilities and the facilities from location to location to try to kind of come up with fairness in the pay scale between different workers. Now, remember, the job evaluation plans were not just about men versus women. It was about people who worked in one situation or did one type of job in a factory versus someone who did a job maybe that was less risky or dangerous, or it didn't require as much skill or experience and so forth. So these job evaluation plans looked at skill, responsibility, effort, and working conditions. And that's the sticking point in this case. And broke each component then into subcomponents, and then assigned point values to each. In other words, American industry had decided we have to have like a system to almost scientifically quantify all of a rubric for how much you should pay somebody to do a job. And that's going to be skill and effort. A skill is going to limit how many people you can find to do the job. And then a job that requires a lot more effort, or where the person has more responsibility, should be paid more. And also someone who has to work in unpleasant conditions. Some jobs have to be done in unpleasant working conditions. And so what they did is they had this elaborate point value system that then they could turn into what was the going wage for a certain type of job. Now, the bill was amended to incorporate the wording used at these hearings. Now, I want you to notice that these job evaluation plans and that phrase, skill, effort, responsibility, and working, were not in the original draft of the bill, but these industry executives, including ones from Corning, it's pointed out in the case, had testified at the legislative hearings. And so their own phrases actually did work their way into the final version of the statute: skill, effort, responsibility, and working conditions. And so the court treated the phrase working conditions, therefore, as a term of art in the industry, reflecting, quote, special meaning within the field regulated by the statute. And it interpreted it to represent the industrial practice that was described at the hearings, and which Corning itself had sort of vouched for or argued for, to account for surroundings and hazards. So the question here really in this case is whether having to work at night is very different working conditions. And the problem was that Corning executives in this case are saying working at night is a different working condition, and that's why we pay people more for working the night shift. But what they had told Congress about how we define working conditions, it was things like hazards and surroundings and stuff like that, and not just whether it's daylight or night outside. So after considering the relevant industry criteria for identifying material differences in the surroundings and hazards, the court concluded that the shift differentials didn't qualify as a basis for pay differentials. In other words, the court took these industry executives' own words when they testified at the legislature and kind of held it against them now in this case, and said basically night shift, day shift doesn't fit with how you were defining surroundings and hazards back when we put this phrase into the statute. And so what's interesting here and why we're studying this case is the opinion actually uses legislative history to figure out what the industry thinks a term means, not what congressmen had in their minds when they enacted the statute. And that's kind of what's fascinating about this. And in fact, the industry, including the defendants in this case, the original party in this case. So rather than identifying a statement by a committee or sponsor and like a senator or congressman, and then attributing that to projecting that onto Congress as a whole as what everyone was thinking, the court doesn't do that. Instead, they infer from the legislative history that some verbiage in the bill borrowed pre-existing technical concepts like working conditions that had been used by the industry in determining pay equity. And so the bill, which then became the Equal Pay Act, adopted 4 concepts that were derived from industry practice and whose content was well defined within the realm of practice. And the record of the hearings pointed the court to an externally verifiable source of meaning of the bill's technical language. And so, and now that concludes our discussion on the case. I want to give you another example from my own experience. When I was a summer associate as a law student at a big firm, and we one of the cases I worked on, I had to get the legislative history for the statute. I honestly don't remember exactly what the statute was about now, but I do remember discovering in the legislative history the only real details were that they were borrowing this statute from the same statute in another state, and I think it was Illinois. And so basically the bill sponsor said, we're getting the statute from this other state where it has worked well and so forth. And then that presents, of course, in statutory interpretation and legislative history, some new questions. But the inference that we would get and present to a court is, you know what our legislature was doing? They intended to adopt the law of this sister state. When they passed this, they expressly the sponsor told their fellow legislators, we're borrowing this statute from another state where it seems to be working well, and we want to kind of be in line with that sister state. And so then it raises a question, of course, if they tweaked the verbiage, how deliberate was that? Or should we read a lot of meaning if there's a difference between the other state statute? And then the other thing is, does that kind of incorporate by reference that other state's case law and holdings on the statute and so forth. There's a general principle, for example, that we'll see in some of our other cases, that if we have adopted another state's statute, that we adopt its meaning at the time as it has been interpreted by the courts of that state. But this is sort of a maneuver in using legislative history to look at not just what was our legislature thinking and intending when they use those words. Sometimes they took those words, copied and pasted them from someone else, and that in itself tells us a whole story. And that's what the court really did in the Corning Glass Works case.